Premiamo la puntualità di coloro che sono già seduti alle 5 come da programma. Iniziamo e ci sarà adesso la presentazione di dottor Giacomo Viggiani ed è un'analisi sulla giurisprudenza della Corte Europea dei Diritti Umani riguardo orientamento sessuale e famiglia. Adesso traduco per now we'll have a presentation dedicated to the analysis of family and sexual orientation in the case law of the European Court of Human Rights, and Dr. Giacomo Viggiani will deliver the presentation. Thank you.
Grazie Marica, anch'io parlerò in inglese, però cercherò alla fine di farvi un riassunto pure io. In ogni caso io nelle slide ho messo dei passaggi che anche ripeterò poi nella relazione, per cui dovreste riuscire a seguire abbastanza bene. Let's start. As you can see from the title of my speech, my aim today is not to provide a comprehensive overview of the jurisprudence of the European Court of Human Rights in respect of homosexuality, a task which will take hours to be accomplished, hours that I don't possess. On the contrary, I will focus on the relationship between family and homosexuality, namely on Article 8 and 12 of the Convention. I'm going to do that in order to highlight some limitations in the Court's approach to this matter, which I believe reinforces, instead of challenging, the heteronormativity of the civil society and the law. Just to be clear, by heteronormativity, I mean the structure of understanding that make heterosexuality not just one way of being, but the privileged one. Regarding Article 8, as you see, we must pay attention, it's made by two parts. The right to respect for family life and the right to respect for private life. And we must pay even more attention that the former does not imply the latter. In particular, the right to respect for private life of Article 8 is quite different, or it should be in theory, from the English-American right to privacy or right to be let alone. For example, in X versus Iceland in 1976, European Commission of Human Rights stated that for numerous Anglo-Saxon and French authors, the right to respect for private life is the right to privacy. The right to live as one as far wishes, protected from publicity. In the opinion of the Commission, however, the right to respect for private life does not have its relationships with other human beings, especially in the emotional field, for the development and fulfillment of one's personality. It is unclear that Article 8 imposes both negative and positive obligation on contracting states, while English-American right to privacy only negative ones. It does not merely compel the state to abstain from interference. In addition to this negative undertaking, which is of course present, there may be positive obligation to be taken, which may involve the adoption of a measure designed to secure respect for private life even in the sphere of the relations of individuals between themselves. Now let's start, after this introduction, let's start analyzing the Court's approach on homosexuality, which is the focus of my speech, as I said. First of all, I need to make a distinction between the complaints lodged by applicants before 1998 and those after that year. This distinction is not arbitrary. The European Court of Human Rights was indeed founded in 1959, but the European Commission of Human Rights provided the function of assessing the admissibility of individual application until Protocol 11 of the Convention came into force in 1998. From 1959 to 1998, the Commission declared the most complaints inadmissible in general, not related to homosexuality in general, because manifestly ill-founded. Until 1980, no complaint at all related to homosexuality reached the court. So the Commission blocked them before. demonstrating a general unwillingness by the Commission to regard homosexuality in any way protectable under the Convention. Let's see an example. A German applicant lodged a complaint with the Commission on 10th October 1955, sorry. It's the fourth complaint ever on this matter, on the matter of homosexuality. The applicant complained about conviction for homosexual offences under paragraph 175 of the Criminal Code of the Federal Republic of Germany, by which he had been condemned to serve 15-month term of imprisonment. This paragraph, paragraph 175, had already existed in the 19th century, but it had been an essential tool used by the Nazis to arrest and deportate homosexual people to concentration camps. Anyway, it was still in force in 1955. The Commission disposed of the complaint in a very concise way. Homosexuality, said the Commission, can be made a punishable offense because it doesn't infringe any of the substantive rights of the Convention. The applicant couldn't appeal to any rights of the Convention. Even if in later complaints the Commission started to recognize that criminalization of homosexual sex interfered with Article 8, with respect for private life, it continued anyway to justify that criminalization, more or less tacitly endorsing the view that the legal regulation of homosexuality was necessary for the protection of the health and moral of society. This is made even more clear in the 1972 with the case X versus the Federal Republic of Germany, when the Commission stated that masculine homosexuality often constitutes a distinct socio-cultural group with a clear tendency to proselytize adolescents, as we know, a long-lasting prejudice. As you probably know, the first successful petition based on Article 8 was decided always in October, but in 1981. It is the well-known case, Litigious versus the United Kingdom, which resulted finally in the Council of Europe requiring that no member states could criminalize male or female homosexual behavior. In Litigious was actually the Commission rather than the applicant who took the lead in challenging complaints relating to homosexuality under the private life provision of Article 8. In doing so, the Strasbourg organs started focusing their attention solely on interferences created with private sexual acts, routinely ignoring the other issue raised by applicants. Anyway, in this landmark case, the court stated that homosexual sexual activities constitute a most intimate aspect of private life and an essentially private manifestation of the human personality. And in the view of this, that particularly serious reasons must exist to justify any interference as necessary in a democratic society. In Litigious, the court made the unprecedented judgment that not only should consensual adult homosexual acts in private be free from interference, but additionally that the freedom to engage in such acts constituted a human right. It was indeed a great success, with no doubt. But how did we arrive to this successful result? In attempting to gain a recognition for homosexuality as a human right, the applicant had tried to demonstrate that homosexuality was a particular ontological understanding of homosexual personhood, the so-called immutable status argument, which the court accepted completely. Nevertheless, the court's ontological construction of the homosexual person as a specific incoherent type of the human being with an essential and immutable personality does not accord homosexuality an explicit value. In other words, despite the recognition of the homosexual as a subject of rights, the court has refrained in Litigious and refrains even now from making any overtly positive statement about homosexual love, relationships and families. In other words, there is no explicit promotion of the idea that homosexual subjects have the same moral value as heterosexuals, and as such should have access to the same universal rights under the Convention. So they can engage in homosexual sexual activities under the right of respect for private life, but that is, okay? Just do that in private. We see it later clearer. Let's come back to that Ian. Indeed, the court, just having claimed that homosexuality is an essential and private manifestation of the human personality, stated that the criminalization of such acts in private does not imply approval, what I have just said. Furthermore, it was not necessary to regulate sexual acts involving a consented adult alone. It was legitimate necessary in a democratic society to exercise some degree of control over homosexual conduct to prevent the exploitation and corruption of those who are especially vulnerable by reason of their youth, the adolescents. Because, as I said before, masculine homosexual people have the tendency to proselytize adolescents, so they are dangerous. In doing so, you can understand how the court gave support to the argument that homosexuality is acceptable, but at the same time it should be segregated from the public sphere. It provides a very little challenge to socially dominant idea about homosexual men as deviant sexual predators, and makes at the same time Article 8, I mean the right to respect for private life, a problematic tool in contemporary European societies where homosexuals seek full citizenship. The year after, the court has consistently attempted to maintain a clear conceptual distinction between private and public manifestation of homosexuality when interpreting Article 8 across the wide range of complaints related to homosexuality, including sexual practices, parent-child relationships, housing tenure, employment, immigration, and so on. A consequence of the court's view that the homosexual acts are protectable under the Convention when take place in private and just in private and not in private, can then enforce the social relations of the closet. Homosexuals gain access to privacy rights when they undertake to keep their sexual practices hidden from the public. This is very problematic because it reiterates the idea that maintaining a strict exclusion of expression of homosexuality from the public sphere is both desirable and necessary. Let's see, for example, the case ADT versus the United Kingdom in 2000. Following a police search of his own, the applicant is arrested and taken to the local police station, where he admits that certain video sites during the search contain footage of himself and up to several adult men engaging in sexual acts in his home. According to the law in force in the United Kingdom in 2000, his sexual activities cannot be considered private because they have involved more than 2 people. You remember Dagen was about 2 people having sex. Okay? Here we have more people. The court, what did the court say? The court stated that the applicant was involved in sexual activities with a restricted number of friends, so Dagen was applicable. But, what is more important, he stressed that it was most unlikely that others would become aware of that was going on, that there was no risk of the activities entering the public domain, and that the activities were therefore generally private. Then, central to the court's decision, therefore, was not the number of people involved, 2, 4, 6, not the number of the people involved in the acts, but the purely private nature of the behavior. This is to say, you can do what you want, but no one must become aware of it. Just take your videos well concealed. Okay? For example, if the applicant had borrowed these videos to his friends, and so these videos had gone out from his home, probably he would have been condemned. Okay? The same emphasis on maintaining a strict division between private and public life is acutely demonstrated by the court consideration of complaints brought by migrants seeking asylum. In the United Kingdom, again, in 2004, for example, the applicant was subject to deportation to Iran by the United Kingdom government, claimed that returning him to a state that operated legal prohibition on all homosexual acts could not be regarded as proportionate under the convention, violating an intimate aspect of his private life. What did the court answer? The court, surprisingly, but not so much after what we have just said, stated they found his Article 8 claim inadmissible because they had not convincingly shown that he was at immediate risk of ill treatment, suggesting that discrete homosexual practices were tolerated in Iran. The court stated, in other words, okay, you are homosexual, come back to Iran and do what you want about it at home. You have a right to private life, so you can do what you want about in your home. Then you see how problematic is the court's strong reliance on public-private binary, because it justifies mechanisms of social control designed to suppress the leakage of homosexuality into the public sphere by the contracting states. By making the private sphere separate from the public one, the court reiterates the heteronormativity of the latter, providing the basis for discriminating against homosexuals in the civil society. Even in Alexeyev versus Russia in 2010, where the court upheld the applicant's complaint about a refusal to permit a public assembly for the purposes of holding a gay pride event, so the applicant won, in other words, the court went to great lengths to stress that the event would not involve any graphic demonstration of obscenity, nudity, or sexually provocative behavior that might criticize in any way public morals or religious views. So you can do your gay pride event, but you do not seem very gay. Sorry for my summary, which is not very well. But as I already said, considering sexual orientation as a discrete aspect of human rights, of human existence, it is protectable when detached from the public sphere does not address this continued discrimination. For this reason, the systematic failure of the court to consider a wide range of issues relating to same-sex relationships under family life provision of Article 8 has not been accidental. Rather, it is the direct result of the court's deliberate reading of Article 8 to separate the rights associated either with private or with family life. The aversion of the Strasbourg to recognizing same-sex relationships under family law provisions of Article 8 is probably due to the pervasive heterosexual imaginary in the conceptualization of the family itself, considering homosexual relationships under family life provision of Article 8 was impossible, because homosexual couples are not family. This is the normal prejudice. We can see this more directly in C and LM versus the United Kingdom. This is the case which took place in 1989, where the Commission stressed that lesbian relationships did not constitute a family life under Article 8. They are not a family. They have a right to private life, so they can be a couple, but they're not a family. The same happens some years later in Mates Tevez versus Spain in 2001, which was related to the awarding of a survivor's pension to the same-sex partner. The court stated that long-term homosexual relationships between two men do not fall within the scope of the right to respect for family life protected by Article 8 of the Commission. So again, homosexual couples are not a family. Finally, in EB versus France in 2008, was the applicant had claimed that her refusal for authorization to adopt a child constituted a violation of her right to family life, since the case was concerned to attempt to create a familiar relationship with a child. The court focuses her attention only on the interference with her private life. This was a lesbian couple. They won the case, but under the private life, not under the family life provision. This privatization of homosexuality continued unchanged until the court pronounced its judgment in Schakenkopp versus Austria in 2010. The court said in this landmark case, the court noted that a rapid evolution of social attitude towards same-sex couples has taken place in many member states. Consequently, the relationship of cohabitating same-sex couples living in a stable de facto partnership fails in the notion of family life, just as the relationship of a different sex couple in the same situation would. With Schakenkopp, finally, same-sex couple falls under the family life provision of Article 8 and not only under the private life. If you remember the fourth case, it takes just 50 years to gain that recognition. So the first applicant is dead by many years. With Schakenkopp, we abandon Article 8 for Article 12, because if you agree that the couple is a family, they could have a right to marriage. Why not? As you know, the Article 8 stated that men and women of marriageable age have the right to marry and to found a family according to the national laws governing the exercise of this right. Like the domestic marriage laws of many contracting states, as well as other international human rights instruments such as the Universal Declaration of Human Rights, Article 12 of the European Convention of Human Rights, they have just read, specifies that the right to marry is limited to men and women. This textual construction has frequently been interpreted to mean that the right to marriage, is delimited to biologically opposite people, and that, as a consequence, same-sex partners are excluded from it. This heteronormative interpretation of Article 12 is not inevitable, since men and women could be understood to encompass same-sex relationships, or Article 8 could be read in light of Article 1, which requires to secure everyone all the rights and freedoms of the Convention. Anyway, the heteronormative interpretation has been the only one accepted by the court until now, Schakenkopp included, and we see that now. For this reason, because of this heteronormative approach, Strasbourg jurisprudence in respect of same-sex marriage is particularly underdeveloped. Unlike in matters relating to the criminalization of private sexual acts, where the court was a world leader in establishing that the sexual privacy of homosexual men was a human right, as we have seen in Dacian, the court jurisprudence on same-sex marriage has shown a little evolution in almost nothing, recorded Schakenkopp in 2010. For example, in the United Kingdom, in 1986, the court stated that the right to marry guaranteed by Article 12 refers to traditional marriage between people of the opposite biological sex. This appears also from the wording of the article, which makes it clear that Article 12 refers to the traditional marriage between people of opposite sex, but it is not true. Because the article says that men and women have the right to marriage, not that the right to marriage is possible just between a man and a woman. In Cossi versus the United Kingdom, in 1990, the court found that the attachment to the traditional concept of marriage, which underpins Article 12, provided sufficient reason for the continued adoption of biological criteria for determining a person's sex for the purpose of marriage. Only in Christian Godwin, or in the United Kingdom, again, poor United Kingdom, in 2002, the court departed from this position and stated that the terms man and woman in Article 12 should not be longer understood to relate to purely biological criteria. Because Christian Godwin was a transsexual woman. Okay? Notwithstanding, Christian Godwin did not impose any obligation on contracting states to grant same-sex couples access to marriage, because Christian Godwin was an M2F, transsexual woman, and the case was therefore concerned with marriage of partners who are of different genders, even if gender is no longer defined by purely biological criteria. Let's now focus on Schakenkopp versus Austria. Thank you, Anna. Okay, let's now focus on Schakenkopp versus Austria, which remains the most serious challenge to the court's criminalization of, challenge to the court's conceptualization of homosexuality, since it focuses attention for the first time not on sex, but on long-term love relationships. The case originated in 2002, when the Vienna Municipal Office refused the male couple the right to contract civil marriage under the Civil Code 1812 of Austria, which states that marriage can only be contracted by people of the opposite sex. By the time the court heard the case, Austria had enacted the Registered Partnership Act, which enables two people of the same sex to become registered partners and thereby commit themselves to a lasting relationship with mutual rights and responsibilities. There are a number of differences between marriage and registered partnership in Austria, with the most significant involving parental rights. On the basis of these recognized differences, the court refused the last-minute application for the Austrian government, who argued that, in light of the Registered Partnership Act, the case should be struck from the court lists, but the court refused that. Anyway, good try, Austria. The applicant, Schakenkopp versus Austria, claimed that since the convention is a living instrument, Article 12, the right to marriage, should be read in the light of the present-day existence of same-sex relationships. The court answered that indeed the institution of marriage has undergone major social changes since the adoption of the convention. Anyway, it must remain between a man and a woman. Consequently, it would be no longer to consider that the right to marry enshrined in Article 8 to limit it to marriage between the two people of the opposite sex. But the court cannot make this change. Because, the court continued, there is no European consensus regarding same-sex marriage. So Article 12 is now open also to same-sex couples. But the court cannot take this decision. Contracting states must. Because there is no European consensus. The problem is human rights are not based on the consensus. Anyway, relying upon consensus analysis in this way enabled the court to bypass the need to engage in any consideration of a proportionality and defer to the Austrian state's marginal appreciation. So it's a decision for Austria. For me it's okay, but let the Austria decide. In conclusion, whilst the judgment in Schakenkopp versus Austria made the positive step of recognizing the same-sex relationships fall within the scope of the family life limb of Article 8, the court's interpretation of Article 12 strongly endorses an heteronormative view of marriage. It continues. Anyway, in other words, the judgment establishes that the separate but equal policy for same-sex couples organized around civil partnership does not contravene rights guaranteed by the Convention. So in a certain sense, homosexual couples are couples which don't have the same, which don't enjoy the same universe of rights under the convention. I conclude my speech with the last case, which is H versus Finland in 2012. What I just said, it's made even more clear in this case, which has been recently referred to the Grand Chamber of the European Court of Human Rights, but with no change in judgment. In this case, the applicant has been happily married to her life since 1996, with whom she had a child. She had been assigned to the male sex at birth, but in 2006 she was diagnosed as a transgender woman. As a consequence, she underwent gender reassignment surgery and started living as a woman. Although the applicant was able to change her first name to female name, her personal documents continue to identify her as male. This is the law in force in Finland. In 2007, the applicant filed a request before domestic courts to have this information changed in order to reflect their self-identified gender identity as a woman. The request was rejected on the ground that the legislation in force made legal gender recognition of a married person contingent on first obtaining a divorce. Okay? So they cannot remain in marriage. They must divorce and then she can ask for the legal change of gender. In fact, in Finland, when the belonging to the opposite gender is confirmed, a marriage is turned ex lege automatically into a civil partnership, and a civil partnership into a marriage. If they had been an homosexual couple, they would have changed a relationship into marriage. Because in Finland, marriage is reserved only for heterosexual couples, and civil partnership only for homosexual couples. There's no other way. It is evident that this law aims clearly at maintaining marriage strictly heterosexual. Of course, the couple who wish to remain married, as ending the union would be contrary to their religious beliefs, and they also believe that civil partnership would provide them and their child with fewer legal rights, and this was true. Okay, because civil partnership and marriage was two different forms of recognition, but they have different rights and duties. They differ not so much, but a little they differ. So the applicant, this transsexual woman, turned to the European Court of Human Rights, arguing that the compulsory divorce requirement in Finnish law was in breach of her rights under the convention. And I conclude with the court's response. The court stated that the differences between the marriage and the civil partnership were not so relevant in Finland, in any case proportional to the aim of the Finnish state to preserve a traditional male-female marriage. So in conclusion, these judgments reinforce the heteronormativity of marriage and the separate but equal policy for same-sex couples. Thank you for listening. Vediamo l'assunto in italiano, ero già contenta, avevo finito. Allora io ho cercato di dimostrare attraverso questi casi quella che è la mia tesi, diciamo, sulla giurisprudenza della Corte CEDO, ovvero che nonostante abbia, come dire, dei grandi passi avanti per le persone omosessuali in Europa, rimane ancora ancorata ad una versione eteronormativa del matrimonio. E in particolare è rimasta ancorata anche ad un binarismo pubblico-privato dell'articolo 8 che è stato molto problematico, perché inizialmente, come appunto vi dicevo, l'articolo 8, che è composto effettivamente da due parti, il diritto alla vita privata e il diritto alla vita familiare, in qualche modo le persone omosessuali venivano escluse dal diritto alla vita familiare, perché si credeva era un pregiudizio che è ancora diffuso, che le coppie omosessuali non potessero costituire famiglia. Erano amanti, amici, quello che erano per la corte, in ogni caso non potevano costituire una famiglia. Quindi avevano diritto a compiere, diciamo, i loro atti in privato, però non potevano accedere a questo livello di riconoscimento ulteriore. Chiaro che un diritto alla privacy all'americana, come si vuol dire, è quasi un boomerang in un certo senso. Ok, non possiamo criminalizzare gli atti omosessuali, però puoi soltanto commetterli in casa tua. Nel momento in cui tu vai fuori, io ti arresto. E quello che accadeva anche negli Stati Uniti. Dopo la sentenza Lawrence contro Texas, siamo anche lì negli anni 2000, si decriminalizza la sodomia, tuttavia non si riconosce nessun diritto nella sfera pubblica. Delle sentenze molto interessanti in cui si nega appunto il diritto a fare la marcia del Gay Pride. Potete sfilare però senza striscioni, perché non si deve capire. Ed è quello che accade appunto nel caso Alexeyev contro Russia. Accade proprio questo. La Russia gli nega già fin dall'inizio il permesso ad allestire questa parata. Loro fanno ricorso in Corte Europea, dopo i tre gradi nazionali ovviamente, vincono in Corte Europea, però la Corte dice sì, va bene, però mi raccomando, non criticate la religione ortodossa, fate i bravi e così via. Quindi fate la marcia, però non date l'idea di essere gay, insomma, è meglio stare un po' sulle vostre. Quindi questa definizione dell'articolo 8 è molto problematica e può essere un boomerang se non è in qualche modo edulcorata con la seconda parte dell'articolo 8, cioè il diritto alla vita familiare, perché allora se si è famiglia anche verso l'esterno, verso gli altri, verso la società civile. In JCIV si ottiene finalmente questo riconoscimento e a quel punto si chiede allora l'accesso ad uno dei diritti che è connessi allo status familiare, che è quello del matrimonio, perché attualmente una coppia di fatto eterosessuale può scegliere se accedere o no al matrimonio, la coppia dello stesso sesso non può scegliere. Quindi loro dicevano, gli austriaci che facevano ricorso, noi godiamo come famiglia un diritto in meno rispetto alle altre famiglie, siamo una famiglia di serie B. Cioè la Corte non dice non è vero, cioè la Corte dice sì, avete ragione, però ha un atteggiamento molto prudenziale che è molto simile a quello della nostra Corte Costituzionale. La sentenza 138-2010 che ha citato Anna Lorenzetti, che è dell'aprile 2010, JCIV è del giugno 2010. Se ne facessimo un tempo, comunque un confronto tra le due, sono molte similarità. Entrambe le corti riconoscono un diritto alla vita familiare, tuttavia, rispettivamente rispetto alle rispettive carte ovviamente, tuttavia non hanno probabilmente non le basi, non hanno forse il coraggio di dire ok, avete ragione, avete diritto anche al matrimonio. Dicono sì, avete diritto, però lasciamolo fare al Parlamento, lasciamolo fare allo Stato membro. Ora, nel caso della Corte Europea dei Diritti Umani è abbastanza comprensibile perché il diritto internazionale è un diritto bellissimo, ma ha un piccolo difetto, cioè che è un diritto che è efficace se gli Stati lo rispettano. Perché, quindi, come dire, è un po' rimesso alla buona volontà degli Stati, per cui la Corte ha assunto atteggiamento prudenziale dicendo l'articolo 12 io lo apro in questo senso, però non c'è un consenso unanime negli Stati, per cui aspettiamo che la società evolva e magari in futuro potremo arrivare anche a questo step successivo. Quindi JCIV è stato un successo, come anche Dagion a suo modo, ma anche in un certo senso una sconfitta, diciamo un mezzo successo. Dagion perché ha decriminalizzato la sodomia, gli atti omosessuali, ma al tempo stesso ha ribadito che decriminalizzare non implica approvazione, non implica approvare, per cui non c'è nessuna affermazione sul valore dell'omoaffettività. Anzi, al contrario, si dice appunto che non c'è approvazione, per cui si può fare, ma deve restare nell'ambito privato. Così in JCIV si ottiene il riconoscimento della vita familiare, si ottiene un'apertura formale dell'articolo 12, ma poi a livello materiale non si ottiene il diritto al matrimonio. Cioè, difatti in Austria godono della civil partnership, che ha dei diritti inferiori rispetto al matrimonio, perché altrimenti non avrebbe senso di esistere. Due istituti paralleli con gli stessi diritti, anche dal punto di vista dell'igiene e dell'ordinamento, non hanno senso di esistere. Se sono diversi, evidentemente ci sono delle differenze che rispecchiano altrettanto evidentemente una differente considerazione delle due tipologie di coppie. Ci sono domande?
Io mi chiedo, ma che cosa può togliere agli eterosessuali il riconoscimento dei diritti al matrimonio? È una domanda stupida, però...
Allora, c'è chi dice che si tolgono magari dei finanziamenti. In realtà questa veramente è una motivazione inconsistente. In realtà non si toglie niente. È una battaglia in realtà che è diventata simbolica. Cioè, o meglio, per le coppie same-sex non è per niente simbolica, è anche simbolica ma è anche poi materiale in un certo senso. Specialmente non c'è nessuno, ci sono poche tutele, se non quelle come guadagnate attraverso la giurisprudenza. Però negli stati come l'Austria, ma anche in alcuni stati degli Stati Uniti, in Finlandia, quella è la posta in gioco. È il valore simbolico che ha il matrimonio, che ha la parola matrimonio. E quindi se noi apriamo il matrimonio alle coppie same-sex, noi automaticamente diamo il messaggio che queste coppie valgono quanto le altre coppie, che non è più immorale essere omosessuale. Questa è un po' quella battaglia di fondo, la resistenza. Sapete che ci sono alcune sentenze, io non devo ricordare, che riguardano altre cose, riguardano ad esempio sempre una discriminazione, mi viene in mente il caso Ueda contro sempre il Regno Unito, se non mi ricordo male, in cui i ricorrenti dicevano: io sono stata licenziata perché mi sono rifiutata di celebrare un matrimonio, una civil partnership, non mi ricordo, in comune, e mi hanno licenziata. Io ho il diritto di discriminare gli omosessuali perché per me sono immorali. Quindi il punto di fondo è questo qua, è la battaglia simbolica per il matrimonio, per il valore della coppia e della persona omosessuale come tutte le altre. C'è qualche altra domanda? Anche sulla parte della laureatezza a questo punto, insomma. There's some questions also in English.
Commenti? No. Prego.
Il mio non è un commento, così è un'osservazione, no? Pensavo, io sono mediatrice familiare ma nasco come psicoterapeuta e ecco, vedendo tutto questo, no? Quindi tutte queste come dire, tante conoscenze vostre in campo legale, di sentenze, mi viene da dire che il campo della clinica nel riconoscimento in qualche modo dell'omosessualità è arrivato molto prima, no? Nel DSM, che è il manuale diagnostico dei disturbi mentali, dunque nel primo DSM l'omosessualità era equiparata a una perversione sessuale come la pedofilia, il feticismo, eccetera, eccetera. Nel DSM del 1974 l'omosessualità è stata, come dire, non più riconosciuta come malattia e questo orientamento vige tuttora, quindi mi viene da dire che perlomeno in alcuni campi viene riconosciuta una, non mi piace la parola, però una normalità all'orientamento sessuale diverso da quello tradizionale uomo-donna.
Sì, ma in realtà siamo arrivati a quello già appunto negli anni 80, nell'81 con Dagion, in America c'è stato il caso Bauer nell'86 che è stato in realtà un fallimento, quindi è venuta una storia un po' diversa, però in Europa nell'81 abbiamo già ottenuto Dagion, per cui in realtà ci siamo anche nel DSM, l'OMS nel 90, comunque ci siamo in realtà sugli anni 80, fine anni 80. Il problema appunto è uscire da questa vita privata. In qualche modo è stata ottenuta, però ci siamo stati in qualche modo ricacciati dentro. E quello che accade in realtà, ora è un po' negli studi di genere, ma è quello che è accaduto in passato anche per il rapporto uomo-donna, per esempio. Si diceva la famiglia appartiene allo stato di natura, per cui lo Stato non deve regolamentarla, e quindi si relegava nel privato le istanze di uguaglianza che invece potevano in qualche modo sorgere, sollevarsi. Ed è quello che